Man killed over popcorn toss. When you think about it, you think that should be on a headline of a newspaper. Big, bold, black letters. Man killed over popcorn toss. Or you're standing in a checkout line in the grocery store, and you look at that. Or you're surfing on the internet, and you see that, and you click it, and you think, well, that's sensationalized. No one could ever think that would take place. There's no way that a man was killed over a popcorn toss. And it's not just rhetoric in this case. It's not something that we talk about and we say as if to make a point, to make it flashy. Because in this case, we know that's what happened. You don't have to look between the lines. You don't have to say, well, maybe, possibly that's what it was over. We know that's exactly what it was over. As flashy and as sensationalized as that sounds, that's what happened. And we know that. How is it that we know that? Because people, 2 to 3 people in the theater heard this defendant say that right after he shot and killed Chad Olson. Derek Friedoff, Mark Turner, and the Summit sent Charles Cummings. These 3 people do not know each other. Derek Friedoff was sitting a row in front of the Olsons and to the left. Mark Turner was sitting all the way to the right in the defendant's row. Charles Cummings was sitting a row in front of Mark Turner. All across the theater, they heard the defendant say, "Throw popcorn in my face." That's why we know this case is truly about a man killing another man over a popcorn toss. These 3 people, Derek Friedoff, Mark Turner, Charles Cummings, they don't know each other. They're not friends. They're not family. There is no evidence that would lead you to reasonably believe that they got together to frame the defendant, that they got together in the theater and they huddled together and they said, you know what? We don't know Curtis Reeves, but let's make up a story that he said, "Throw popcorn in my face," or some words to that extent about the popcorn. It would be completely unreasonable to believe they got together to frame the defendant. Some grand conspiracy. This case is absolutely, unfortunately, about a man killing another man over a popcorn toss. Now, you don't have to really read too much between the lines or go very far below the surface to determine why this happened. Now, when I say this, I am not saying this as an indictment on law enforcement in general. We are only talking about the defendant. And what do we know about the defendant? Well, there's certificates and evidence. A career law enforcement officer, trained in de-escalation tactics, not only through the department, but through Busch Gardens. How you take a volatile situation, and I submit to you this wasn't even a volatile situation, but how you take the most volatile situations and you de-escalate it, lower the volatility. Yet, despite all that training, instead of de-escalating the situation, the defendant instigated the situation. The defendant started it, and he stopped it. And what you have to look at is what's happening here. Here's an individual. The defendant is a person that I submit to you based on the evidence likes those danger situations, likes the adrenaline, the units that he was involved in. He likes the control. Now, I'm not saying there's anything wrong with leadership. Of course there isn't. That would be silly to say. But likes the danger and likes the control. And that's how he started this, that's how he instigated it, and that's how he ended it. And that's what this case is about. It truly is about a man who killed another man over a popcorn toss. Now, the defendant wants you to believe this, and I submit to you that both versions of the events that the defendant told you are absolutely 100% not credible. And I submit that you know that already. The defendant wants you to believe this. A retired captain from the Tampa Police Department who's been involved in robbery, homicide, fugitives, the Special Weapons and Tactics Team, also known as SWAT. Remember during his testimony what he said. Man, it's eye-opening. When I first started, the level of violence and the dangerousness, you wouldn't believe it. Yet that very same person wants you to believe that in all his years doing all those jobs throughout Tampa, The one person that scared him the very most, the one person that he had to shoot and kill, was in theater number 10 on January 13th of 2014. The person that scared him the most is a father and a husband that said, "Leave me alone, I'm texting my daughter." Maybe Brad Olson scared him the most in his entire life in that moment in theater number 10. I'm texting my daughter. He reaches and he grabs a popcorn and he throws it at him. In his entire career, that's the most he's ever been scared. Absolutely unreal and unbelievable story. The defendant in this case shot completely out of anger. And we know that because of the words that he stated afterwards. And not only that, you're going to have the videos back there with you. You're going to have the state video, you're going to have the defense video. They're both basically the same. Very minor differences. Watch the reaction that the defendant has when he's shooting, because that demonstrates the anger, the explosion, and that's why those words come flying out of his mouth immediately after he shoots. He lunges forward. He's not back in a life or death struggle like he wants you to believe. And we're going to talk about his stories. That is absolutely not what happened. He lunges forward. And how was he able to do it so quickly? Because when he was moving back, that gun was at his hip already. That's exactly what happened. That's how he was able to fire. He already had it at the ready. But we're going to talk more about that later. Now, when he's interviewed in the cruiser, think about this. Now, you have that tape statement. Listen to it as many times as you want. Okay, and again, those videos are on the computer. You're going to have a computer that's going to go back with you. So you're going to be able to look at the videos. There's a player. You can move it back and forth like we are doing on cross-examination. When you listen to that post-Miranda statement, think about it. Now, you have to rely on what you believe is in that statement. I submit to you it shows a cool, calm, and collected person telling an unbelievable story in order to justify what he had done. A very self-serving statement, and a self-serving statement does not equal self-defense. A retired police officer sitting in a cruiser, cool, calm, and collected, making up a story that is contradictory to every witness in this case. There are 7 to 9 eyewitnesses in this case, including 2 that the defense called. And none of them even remotely touch the story that the defendant wants you to believe, including his wife. Sitting right next to him, inches away. She didn't see some violent life or death struggle. Do you think that she would have noticed something like that? Of course, because the defendant's story is 100% untrue. A self-serving story. Now, why did he tell that story? It's a great question. I submit that he told that story because he had no idea that so many people observed what happened in that theater. But here's what he really didn't expect. The silent witness. Who was the silent witness the defendant never in a million years thought was going to speak the loudest words in this case? It was that video. I submit he had no idea there was a video in there. The silent witness spoke the loudest because when you watch that video, every single thing that he said was untrue. Every single thing. And then he came into court and took that stand and looked you in the eye and told you a completely different story from the unbelievable one in the cruiser. Why is that? Because he knows what really happened on January 13th of 2014. Just like the witnesses that came in and told you. Just like the video tells you. He shot and killed a man over a popcorn toss. He started it and he ended it. End of story. Now, we had a jury trial the past 3 weeks. When we have a jury trial, the state, sometimes people call us the government, okay? But it's the state of Florida. It's the 3 of us prosecuting this case. We have to prove the case to you beyond a reasonable doubt. That's our burden. We gladly accept it. It should be that way. Now, what is a reasonable doubt? At the conclusion of the case, you're going to hear all of the law. I get a copy of the packet as well. So you don't have to memorize the law. It's kind of complicated. We're going to go through it. I have a lot of boards and an easel. We're going to go through the law. Okay? Now, a reasonable doubt. This is part of the instruction. A reasonable doubt may come from a lack of evidence, and it may come from a conflict in the evidence. Now, I submit to you there is no lack of evidence in this case. 7 to 9 eyewitnesses and the video. And the defendant's self-serving statement. It's almost like when someone says they didn't commit a crime because they have an alibi in another county, but then it's proven that they're in the county. It's like, why make up such a story? A conflict in the evidence, let's talk about that. I submit to you whenever there's a jury trial, there is a conflict in the evidence, right? I mean, just the very nature of a dispute is there's a conflict in the evidence. And that's not a reasonable doubt in and of itself. Because if you think about it, then you could just have some people come in and say, well, I said it's red, this person said it's blue, conflict in the evidence. How would you ever prove a case? You couldn't. So what do jurors do? Obviously, what a juror does is you take all of the evidence. There's a lot of evidence in this case. And you got to sift through it, you got to look at it, you really got to analyze it, and you got to say to yourself, what evidence here is credible? And Judge Barthel's going to read you an instruction. And what she's going to say is you can believe all of a witness's statement. You can believe none of a witness's statement. You can believe some of it, discard some of it. That's totally up to you. And what's interesting about this case is we have a mixture of all of that. There are witnesses where you can believe everything they said. You could take some of what people said. Vivian Reeves' testimony, Jennifer Shaw's testimony. You could take some of that. Others of it, I submit, you're going to have to discard because it's certainly not credible. Ultimate bias in that. But we'll talk about all this. You can completely disregard a statement. Both of the defendant's statements are completely unreasonable based on the totality of circumstances. He didn't fear anything. He wasn't vulnerable. He was an instigator. He started it and he ended it. So just a conflict in the evidence isn't a reasonable doubt. You have to take all the evidence, find out what's credible. So what you do is you take the not credible evidence, you put it aside. You take the credible evidence and you look at it. And we're going to go through the elements of the crime. So you take the credible evidence and you apply it to all the elements. And what you do is you start with the highest crime charged. And again, we'll talk about all that in just a little bit. But you take the credible evidence, you apply it to the law, that's how you come up with a just verdict. Now, the other instruction that is contained within a reasonable doubt is this. A reasonable doubt is not a forced doubt, an imaginary doubt, a possible doubt, or a speculative doubt. Okay, I'm going to repeat that because it's really important. It is not, and the most important two are possible doubts or speculative doubts. Those are not reasonable. So there's a story that I tell for every closing argument. Obviously, I'm going to tell it today. So let's say that it's the summertime and you're out walking your dog and it's nighttime and you hear thunder, you see lightning, you smell rain, and you go to bed. When you go to bed, you wake up and your neighborhood is soaking wet. Has it been proven beyond a reasonable doubt that it rained? Absolutely. Because common sense tells you that. And remember, you don't leave your common sense at the door. Thunder, lightning, smell of rain, your common sense, it's been proven beyond a reasonable doubt it rained. Now, is it possible the neighborhood kids went walking around that night when you were sleeping? You got Christine, you got Carol, you got Jeff, and you got Bad Brian, okay? Now, is it possible that Bad Brian went out and took a super soaker gun and sprayed the whole neighborhood with water while you were sleeping? I mean, you could talk about that any day. Is it possible the sun's not going to rise? Based on the evidence, thunder, lightning, smell of rain, and your common sense, basically what comes from the witness stand and what's in evidence, it's been proven beyond a reasonable doubt that it rained. It's not possible Bad Brian did that super soaker thing. That's ridiculous. That's not reasonable. Now, can you speculate that a helicopter went over the neighborhood with a bucket of water going to a fire and that the bucket of water landed on the neighborhood? Sure. But based on thunder, lightning, smell of rain, and common sense, that is completely unreasonable. Can you speculate your car's not going to start tomorrow? Sure. But that's unreasonable. So those doubts are not reasonable. So you got to be careful when you start getting into possibilities and speculation. You have to focus on the credible evidence. So let's talk about speculation, because there's so much speculation in this case. It's really important to talk about it up front. I'm going to call these speculations shiny objects. Because what happens with a shiny object? See, if you look at a shiny object, let's say there's a whole bunch of shiny objects floating over here. If you look at those, you're going to forget to look over here at this table where all the credible evidence is. And when you look at all that credible evidence, I submit you're going to find the defendant guilty of either murder in the second degree or of manslaughter. Because these shiny objects, if you look at them, you lose focus of what really happened in this case. So I have a list. It's a fairly long list of shiny objects. Now, if a lot of questions are asked about a shiny object, or you yell about a shiny object, the only thing that happens is this: it doesn't become any more relevant and it doesn't become any more important. It becomes shinier. That's all that happens with shiny objects. So let's talk about all the shiny objects, the unreasonable doubts in this case. The sheriff's office should have recreated the scene, and the theater was too dark and too loud. That's a shiny object. First of all, it'd be impossible, literally impossible, to recreate that scene. The best law enforcement agency in the world couldn't recreate that scene. And why is that? Because think of all the moving parts. You'd have to know where everybody was seated. Not only that, what angle they were at any given time, because every angle would be important. Where the Olsons were, where the defendant was, where all the witnesses were, what the exact scene was at that exact time, while they were in that angle, while someone was talking or not talking. Every single thing would matter, and you can't recreate the scene. It's impossible. A light meter wouldn't tell you a thing. A sound meter wouldn't tell you a thing. Who tells you? Witnesses. They take the stand under oath. They tell you what they saw, what they heard, and none of them got together to frame anybody on January 13th of 2014. It's impossible to recreate the scene. So when a paid witness for the defense gets up there, Michael Knotts, and talks about recreating a scene, it's impossible. We wouldn't bring that to you. I submit to you there would be a very long cross-examination about it. Like, how could you possibly tell this jury that this scene could be recreated? Plus, how would you even document that? A camera would never in a million years ever tell you what an eyewitness can tell you. Just can't happen. It's a shiny object. Now, was it too dark? Remember at the beginning of opening arguments, I said, hey, please make sure that a witness is not pigeonholed into one word. Remember, muted, dim, dimmer, dark, darker. One word means nothing. What's important is the picture that's painted. And you saw it happen during the trial. Now, what did all the witnesses tell you? Even Joanna Turner, and we're going to talk about her. All of them told you, yeah, it was dark. It was muted, it was dimmed, but we could see. We could see. We could see 5 seats down. We could see 10 seats down. When we get into the theater, we can see. That's the real evidence in this case. And what they saw was the defendant started and ended. What they saw was the defendant kill another man over a popcorn toss. Now, could they hear what happened? Oh, it's so loud. The previews are so loud. We couldn't possibly hear it. Well, that's not true, because every witness came in here and they told you, yeah, previews are on. But we could hear. Now you think about the layout of where everyone was in that theater. You have the defendant with his wife sitting in the back row. Directly in front of them is the Olsons. Going back into the defendant's row all the way to the left are the Hamiltons. They could see, they could hear. You go all the way to the right, you have the Turners, Joanna and Mark. They could see, they could hear. Even closer is Jane Roy. She could see, she could hear. Then you have the Olsons. To the right of the Olsons, you had Charles Cumming. He could see, he could hear. Then in front of the Olsons, you have Derek Friedoff. He could see, he could hear. Nicole Olson, even Vivian Reeves. There's not a question if it's too dark. or it was too loud. Now, there was an interesting moment, though, in the trial. There was a very interesting moment. Okay? You remember Matt Reeves, and we're going to talk about Matt Reeves. Okay? I would submit to you that Jennifer Shaw and Matt Reeves were in a tough situation. They were credible and not credible at the same time. But Matt Reeves said something that was really interesting. Now, think back to the defendant's first statement in the cruiser. Again, it's an unreasonable statement. Didn't happen. I mean, it absolutely didn't happen that way. But think about what he said. He said that while he's leaning back in this life or death struggle, he's yelling what? What's he yelling? No, 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 and whoa, whoa, whoa. What's Matt Reeves say that he heard when he came into the theater? Now, you rely on your own recollection. I could be paraphrasing it. He said two different things, but he said, I heard, get out of my face, or something like that. And then defense counsel asked him, well, how did you recognize it? Well, it's my dad's voice. Of course I heard it. Now, think back. I'm sure you know where I'm going with this. Think back. Who in this case said that somebody said at that point in time, get out of my face, or words to that effect, stay out of my face? You can't confuse no, no, no and whoa, whoa, whoa with get out of my face. But who told you that was said by somebody?
Come back into the movie, and they got to put his phone away. Like, thank God. I said, I see you put it away. I told the manager for no reason. In other words, I went in and ratted him out. He was going to put it away with his own, you know, interactions. And he turns around in his seat and he says something about he was, I don't remember,
So who is saying that someone is saying words that are close to that? The defendant. So was Matt Reeves able to hear Chad Olson telling this defendant, basically, stay the hell out of my face, leave me alone, stop instigating me, just leave me alone? So was it really too loud? Or did Matt Reeves come in here just to try to say the defendant said it because he wanted to help out the defendant? Matt Reeves is also the only witness that said it was nearly pitch black. Not a single witness told you that. Not a single witness. The Sheriff's Office investigation, a shiny object. In fact, it was a super shiny object. We heard many witnesses. Extensive cross-examination. There was a suggestion that the Sheriff's Office investigation was bad. I'm going to use a very non-legal term here. There's a suggestion that the Sheriff's Office investigation was crappy. You know what? The Sheriff's Office investigation was crappy. Absolutely. It was a terrible investigation. There's no doubt about that. You could bring in one witness, you could bring in 50 witnesses. There's not a single person that would listen to this case and say, wow, they did a fantastic job. They did not. Absolutely did not do a great job. No doubt about that. But it's an incredibly shiny object.
Scott Rosenwasser giving the closing argument for the state of Florida. We're going to step aside, take a short break. We're going to rejoin right where we left off. You won't miss any of it. We do have some breaking news to pass along. President Biden has made a decision. He's set to nominate federal appeals judge Ketanji Brown Jackson to the Supreme Court. Not a huge surprise. This is according to the Associated Press. She was a front runner from the very beginning. It is a historic move. This will make her the first black woman to serve on the nation's highest court. Let's bring in trial attorney and former president of the National Bar Association, C.K. Hoffler. Your thoughts, C.K., on this decision? Not a huge surprise.
It was not a huge surprise, but what a great decision. And I applaud the president for this decision and for announcing it at this time while we're amidst a war. But this is such a magnificent development. She, Judge Ketanji Brown Jackson is eminently qualified. She has clerked for Justice Breyer. She has the judicial temperament to serve in this capacity. She has the leadership. She has an incredible background, a diverse background of experience for a lawyer, and that makes her a phenomenal nominee for this position. She also secured bipartisan support when she was confirmed within the past year. And so on all fours, if you have to check all the boxes, she meets the criteria. But most importantly, for me and for so many, because she is an African-American woman, she is making history, and she is so broad and diverse, has such richness in her background, having represented the least of these. And certainly that perspective is going to be very important on a lot of the issues that the U.S. Supreme Court will be facing. So I think that this is a magnificent development. I applaud also the other front runners, Judge Kruger, Judge Childs, who also were phenomenal candidates, and I could not be more excited for the president's final pick.
All right, and the formal announcement expected later today in Washington. CK, thank you. We're going to step aside, take a break. When we come back, we'll pick it up right where we left off. It's closing arguments on a Friday, right here on Court TV. Stay with us.
How's she doing?
Welcome back. 8 years ago, Curtis Reeves, a former Tampa police officer, shot and killed Chad Olson in a movie theater. Today, his fate is in the balance. He may be walking out of this courtroom at the end of the day, or he may be headed to prison, potentially for the rest of his life. He's 79 years old now. We're watching the closing arguments from both sides. We're going to pick it up right where we left off. Scott Rosenwasser is delivering the close for the state of Florida.
A super shiny object to take you away from looking over here. Because in reality, it doesn't mean a single thing in this case. Now, do we want law enforcement to do a great job? Of course we do. Kidding me? But in this case, it didn't mean a thing. Because we brought in witnesses, eyewitnesses, credible eyewitnesses. And you saw how they were cross-examined. They were tested. It doesn't mean a thing that the sheriff's office didn't do a great investigation. Think about all the witnesses that testified in this case. I'm gonna try to name the most important witnesses. You had Nicole Olson. You had Vivian Reeves even. Her testimony kind of meant something because what she doesn't tell you speaks volumes. Jane Roy, Joanna Turner, called by the defense, Mark Turner, the Hamiltons, Angela and Alan, Charles Cummings, Derek Friedoff, 9. They came and told you what happened. It doesn't matter. Let's say the sheriff's office, just for the sake of argument, asked one question of each of those witnesses. Does that mean when they came in here and testified about what they saw and what they observed, it doesn't mean anything? Of course not. It doesn't matter in this case. Not a single bit. You could just remove the sheriff's office from the whole case in this case. Now, there are some investigations where it really does matter. Thankfully, it's not this case. It's a big, shiny object. We absolutely agree they could have done a better job. Not only do we have all those witnesses, we have the silent witness, the video, that tells you what had happened. The detectives, this is shiny object number 3, the detectives didn't have the qualifications. They didn't know enough about self-defense to be involved in this case. All right, let's talk about that. Doesn't mean a single thing, okay? You have a defendant here who has all this law enforcement experience. It's not some unsophisticated person that for the first time he's ever been interviewed. And when you listen to the post-Miranda statement, he's asked plenty of questions. But let's say he was just asked one question. Do you really believe that this defendant didn't understand what was important to tell the detectives and that the interview was the defining moment? He knew enough to make up a story to justify an unlawful shooting. Perception distortion, he's throwing out this terminology. He knows what's going on. Perception distortion is not when you make up an attack that never happened, okay? That's just called being untruthful. It has absolutely no bearing in this case at all. It's a shiny object, means nothing. So when their paid witness takes the stand and says, oh, you'd like to ask him these questions, at the second time, and it's on tape, Detective Proctor, when he goes back to him, he says, hey, is there anything you want to tell me? No. But you know what he does says? You know what he says? And we'll talk about it again later. You know, I'm back here, and I'm second guessing. You know, I'm not sure he hit me. This incredible hit that scared him to death, that no one saw, I'm not really sure that happened. That's what he says. You don't get second chances when you kill somebody. It's a shiny object. Shiny object number 4, witness contamination. You can talk about it with 50 witnesses. You can yell about it. It means nothing. It becomes shinier. There is no evidence at all of witness contamination in this case. In fact, we have so much evidence against it when you think about it. Okay? First, you go with the basic premise, no one really knew each other, and they wouldn't get together in the theater to conspire to frame Curtis Reeves. Well, then you might say, well, maybe they just absorbed some information and it was planted in their mind like Inception, and now they're testifying. That is ridiculous. That's the very definition of an unreasonable doubt. And you had an opportunity to see them on the stand and judge them and observe how they were testifying. But here's the point that I'm making. Think about Joanna Turner and Mark Turner and that testimony. Joanna Turner, some of what she said I would state to you is credible, some is not credible. And we'll talk about Joanna Turner in a little bit. But with witness contamination, that shiny object, think about this. They lived together. Joanna Turner said she spoke to Mark Turner. She shared her information about this thermos that, just for whatever reason, she believes there's a thermos somewhere. Well, we know there's no thermos. She said it absolutely wasn't a cell phone. We don't know what happened there. But my point is this. They shared that information. Did Mark Turner come in here? Did he take that stand and say, oh, I saw a thermos too? No. It's the opposite of witness contamination. She shared information with Mark, but they testified differently because they came in here under oath. They told you what they saw, what they heard, and what they observed. It's the opposite of witness contamination. It's what's supposed to happen. It's a very shiny object, witness contamination. It sounds terrible, but it didn't happen. And there's no proof at all. Well, there's people sitting at a table. Who are these people? Any proof Derek Friedoff got with Mark Turner, or that Mark Turner got with Charles Cummings, or Charles Cummings got with Alan Hamilton? That's pure speculation and an unreasonable doubt. It's a shiny object. All right, shiny object number 5. Detective Proctor interviewed 2 witnesses, which are the Hamiltons, for 5 minutes off tape. What does that mean? That means this. Detective Proctor interviewed 2 witnesses off tape for 5 minutes. That's all it means. They came in here and they testified. Shiny object number 6. We already touched on that. The detective's interview. Maybe they weren't asking the right questions. The defendant knows what he had to say. He made up an entire story. The witnesses came in here. They told you what they saw, what they heard, what they observed. Shiny object number 7. A holster was in Detective Proctor's drawer for 1 week locked up. Oh my goodness, there was a holster in his drawer for a week. So what does that mean in this case? What is this shiny object?
We're just taking a quick break. We'll pick it up right where we left off. Stay with us.
Retired police captain Curtis.
Welcome back. In just a few hours, the fate of 79-year-old Curtis Reeves will be in the hands of a jury. After the attorneys finish their closing arguments, the jury will be tasked with deciding if the defendant acted in self-defense like he claims when he shot and killed Chad Olson in a movie theater 8 years ago. He's accused of second-degree murder and aggravated assault for the 2014 incident. Reeves spent hours on the witness stand Thursday telling the jury about his career in law enforcement and the day that he shot Olson in the theater. We'll soon find out what effect his testimony had on those 6 jurors. Let's take you back now to the Dade County courtroom, right where we left off. Prosecutor Scott Rosenwasser delivering his close.
What does this shiny object mean? It means this. There was a holster in Detective Proctor's drawer locked up for a week. That's exactly what it means. Now, if this holster was important because it was a whodunit case, because there was blood or something on it, and it would degrade in his drawer for a week, well, then it's a big deal. It wouldn't be a shiny object then. It would be a big deal. Is this case about the holster? Or is this case about the defendant shooting another person? Obviously, you know the answer. The defendant started it. The defendant ended it. Shiny object number 8. The video surveillance was taken by Cobb Theater employees, and all the way out of state it goes. And then it comes back in a box that no one opened until it had to be opened. All right, what does that shiny object mean? It means this. The DVRs from the Cobb Theater were taken, and they went all the way out of state. And then they came back in a box that was locked until someone had to open it. And now you get to see that very video. A video from the state and the video from the defense. And when you watch it, whatever the subtle differences are, it basically tells you what happened, because that's the silent witness. It did go, and it came back, and you watched it. End of story. It's a shiny object. Was it the best practice? Of course not. No one would argue it's the best practice, but it doesn't matter. Shiny object number 9. This is the testimony of Jennifer Shaw, Matt Reeves, and to some extent Joanna Turner. I want to be very clear on this point. Jennifer Shaw and Matt Reeves are absolutely not bad people. They are not bad people at all. They're good people. But in this particular case, for this time frame, testifying for the defendant, they're just not credible. Has nothing to do with who they are as people. They're just too biased because they're too close. Now let's talk about Jennifer Shaw's testimony. You remember she took the stand and she started crying. And I'm not making fun of the testimony. I just have to point out to you things that were just not right. So she takes the stand and she starts crying. And what's the first thing that she cries about? You know what? My dad asked me for the first time to help him. It was so shocking to me. He was deteriorating before my eyes. And she starts to cry. And this was over the kayak paddles. Now, this is why cross-examination is good. You know, it's good for the state, and it's good for the defense, absolutely. It's the purpose of it. So what really came out after the tears about the deterioration of the defendant? What happened that day? The paddles, the kayak paddles, were actually stuck. And together, they twisted and pulled. Now, there's a lot of times that we went through probably some incredibly painstaking questions about physical ability. And if you were watching this trial and you just tuned in, you were probably like, what in the world are you all talking about? Well, you all know what we are talking about and why we are doing it. Because if there's the suggestion that the defendant shot and killed another person in a movie theater because he perceived himself as vulnerable, because he's a fragile egg that at any moment can break and be killed by either popcorn or even a fist, we got to address it. And that's the reason why we did it. Did it seem like a lot of information? Sure. There's probably points and times where you were like, oh my God, we can skip these 7 hours. But it was important to bring up. So Jennifer Shaw, she's crying. I'm watching my father deteriorate before my eyes. But all that happened was the paddles were stuck, and together they were able to twist and pull, and boom, after 10 minutes together of doing that physical activity, they were able to pull the paddles apart. So was he deteriorating, or the paddles were just plain stuck? That's it. And on cross-examination, what did she tell you? Okay? Actions always speak louder than words. The defendant's words don't mean anything, meaning his statement to police and on the stand. His actions, what you observe and what other people say, mean everything. We saw a video. We're going to talk about Dr. Foley in a second about all these x-rays and MRIs that were done like a year or so after this happened. What can the defendant do? What did Jennifer Shaw tell you the defendant can do? He can bike, right? Mountain bike, road bike. He can kayak, wiki-wachi. That's 3 or 4 hours of paddling, lots of turns. He would hunt, walks around the neighborhood, pulls a wagon, washes cars, pressure washes the house, mows. You know in Florida that if you don't mow after a week, it's a jungle. Mows on his electric lawnmower, washes cars, prunes hedges, shoots sporting clays, shoots bows and arrows. The list went on and on and on. Just days before this shooting, what was he doing? Did he perceive himself as this vulnerable, fragile egg as he went 10 feet up into a tree to hunt? Walked at 100 yards each time, was able to sit in the car for long car rides, could drive up to North Carolina. And it seems kind of silly, but all those things take coordination. And if you have so much arthritis and you're deteriorating to that point, you can't do it because it's not the right picture being painted. That's why it's an incredible shiny object. Matthew Reeves, the only person to say it was nearly pitch black, okay? They're not bad people. They're just not good witnesses in this case. Too close to home. Joanna Turner. Joanna Turner was called by the defense. Now, why didn't we call Joanna Turner? So think about this. Let's say there's a traffic crash. You got 5, 6, 7, 8 witnesses that tell you the light was red. And they don't know each other. And there's no reason they'd make it up. And then you have one person that says, you know what, I saw it and the light was green. What would your common sense tell you? It would tell you, you go with the red group. Joanna Turner, the shiny object Joanna Turner, is in the green group. For whatever reason, she perceived something that resembled a thermos. There's no thermos, but I specifically asked her. Now, her testimony, I'm sure you all recognize this. You use your own opinion. Maybe the last person that spoke to her, that would be the answer she'd say. But what she said was for sure it wasn't a cell phone. Now we're going to talk about the cell phone in a little bit. That's an incredibly shiny object in this case. So there was no thermos. Now let's just say there was a thermos and there's no evidence there was. What did she say? Well, at the time that I saw this flicking motion of what she perceived to be a thermos, she didn't even think anything violent was happening because she just went back to watch the preview. But that's why we didn't call Joanna Turner. Not that she intentionally was misleading anybody, she just didn't perceive it correctly. Why bring that evidence before you? That's why Joanna Turner wasn't called. Shiny object. Getting to the end of the shiny objects. Number 10, the testimony of Dr. Foley, Dr. Adams, and Dr. Cohen. Dr. Adams charges $450 an hour. You would remember him. He used to be the medical examiner at the Hillsborough County. Took the stand, went through an incredible amount of information. Basically,
as we approach the top of the hour, we need to step aside, take a break, and we have a short programming note here, a new Court TV special on the cases that are Black History in the Making. Airs tonight. Court TV anchor Michael Ayala will have an all-star panel with him, including attorney Benjamin Crump, Mark O'Mara, of course, the man who defended George Zimmerman, who was later acquitted of killing Trayvon Martin. Also on the panel, our favorite Court TV guest, C.K. Hoffler, will be there. Michael will take a look back on the Black icons of the past and talk to the panel about the cases changing the course of history as we know it. And I'm sure they'll talk about the Supreme Court nominee announced this morning as well, formally announced later. You can watch it tonight, 7 o'clock, 6 Central, right here on Court TV. When we come back, we'll pick it up right where we left off. It's closing arguments in the movie Popcorn Murder Case. Stay with us.
2 loads of snot.
Welcome back to Court TV and a busy Friday. We're watching two trials play out this morning here. First in Louisville, Kentucky, former police officer Brent Hankinson's actions on the night of the police raid where Breonna Taylor was killed is the focus of the trial. Prosecutors claim that Hankinson went against protocol when he fired his weapon, endangering the lives of Taylor's neighbors. You can watch that trial, if you like, over on CourtTV.com. We're streaming it there and on our YouTube channel, and of course then in Florida. Today is a big one. Its closing arguments are underway this morning in the movie Popcorn Murder trial. Defendant Curtis Reeves spent all of yesterday on the stand testifying to what he claims happened just before he shot moviegoer Chad Olson. He told jurors that he thought he saw Olson throw a cell phone at him. But surveillance video was shown again with Reeves on the stand, and at times it left him seemingly without answers. Now let's take you back into that Dade County courtroom. Prosecutor Scott Rosenwasser is delivering his closing argument. We're picking it up right where we left off.
This was the testimony, I believe. Dr. Adams was speculating about all the possible events that could happen to the human body. At some future time, in some unknown way, with some unknown variable, hitting some part of the body might possibly, maybe, hurt somebody or kill them. That was basically his testimony. But here is really the telling moment with Dr. Adams. Now remember, of course, he's being paid. Now, I'm not telling you that people that come to testify shouldn't be paid. They got to pay their bills. Of course they should be paid. But you can consider that as part of their bias, right? So he's paid $450 an hour. Now think about this. What's important in this case? Well, we have eyewitness testimony and we have a video that Chad Olson did reach over. He should though, okay? And he grabbed the bag of popcorn, he flicked it, and as his hand was coming back, once that act was completed, he was shot and killed. Nothing was happening from that moment on. His hand was coming back from the popcorn, and that's when he was shot. So, the defense asked Dr. Adams, well, why don't we see stippling on his fingers? And the answer was, now you rely on your own recollection. Remember, what the attorneys say, it isn't evidence. I recall he said that because he had a fist, that's why there was no stippling. Well, Mr. Martin got up, and Mr. Martin was cross-examining him and said, well, at a previous time, didn't you say that it was because his fingers were outside the cone of the stippling? Oh, no, I didn't say that. And they went back and forth for a little bit. So finally, the document is shown to Dr. Adams, and what's he say? Yeah, you know what? Now think about this. This is a very intelligent guy. He used to be the head of the medical examiner's office. I didn't understand Mr. Martin's question. So Mr. Martin said, well, today you said you didn't understand the question, and I asked it again. You didn't ask during that sworn statement for me to repeat it. You must have understood it. Again, he's not some bozo. He's a very intelligent person. Now, how is it then that he didn't understand such an important question? I mean, that's a really important question in this case. Well, once he's confronted with it, and he's like, well, gosh, I really can't say that. I mean, I had to have understood it. Then what did he say? The court reporter took it down wrong. Because she's got some motive to do that. I mean, you can mistype a word, you can misspell it, you can switch a word around, but you can't change the entire context of a statement. I mean, just Dr. Adams wasn't credible. Dr. Foley, we already talked about him. That's the x-rays. Actions speak louder than words. We're not going to go through all of Jennifer Shaw's testimony again. Dr. Cohen came in, and she told you that when people get older, they age, and their bodies change. And you know what? When people get older, they do age, and their bodies do change. In fact, the defendant was older, and his body changed. Doesn't mean a single thing. Let's say he was sitting in a theater with 2 broken legs and a rotator cuff injury, and someone threw popcorn on him. Oh, well, now that he's got 2 broken legs, he can shoot and kill somebody. That totally makes sense. You know what? His back's hurting really bad. He's got a herniated disc. Popcorn goes on him. Yep, absolutely. We can kill him. Sure, you get older, you can just kill people. But actions speak louder than words. All of that testimony are shiny objects. And she talked about people perceiving themselves as vulnerable, and if they perceive themselves as vulnerable, that's why they may do a certain action. Is the testimony and the evidence and the video in this case, does it demonstrate that the defendant perceived himself as vulnerable? Absolutely not. Did he try to de-escalate things because he felt vulnerable? He leaned in twice to Chad Olson. He instigated. He started. Did he perceive his health as deteriorating? I mean, all these little things we talked about seem so silly, and I almost hate to bring them up. But the week before, he's hunting and going up in trees. That day, he drives. It sounds silly, but his wife could have driven. Could have dropped him off at the front if he was such and such poor shape that day. They chose the back row, for crying out loud, all the way in the middle. If your back hurts, you're going to sit at the aisle because you don't want to walk around people. We all know how uncomfortable that is. And yes, of course he used the wall for balance. No one wants to step on people's toes. If you have such concerns for your safety and you perceive yourself as vulnerable, you don't do a single thing the defendant did in this case. And it just goes along with his statement. It's so untrue. And that's why you keep going back to, it sounds sensationalized, but he started it, he ended it, and he killed someone over a popcorn toss. The last shiny object, and then we're going to talk about the facts of the case with the law. Cell phone DNA. The more you talk about it, the louder you talk about it, just makes it shinier. Look over here, don't look over here. Why is there no DNA on that cell phone? I mean, obviously you all know why. There's no way ever in any fact pattern.
Judge, I'm going to object. That's a misstatement of the evidence. There is DNA on that phone.
Okay, I'll rephrase it.
Thank you.
There is DNA that is uninterpretable on that phone. It doesn't matter. It literally doesn't matter. There is no way ever that phone was used in this case against the defendant. Ever. Not a single witness sees this phone event take place. And his wife, who's sitting next to him, do you think that she would have seen a violent attack with a cell phone happen if she's sitting right next to him? Well, I closed my eyes. Come on, really? All the people in the theater didn't see it. The silent witness video doesn't see it. The defendant has no injuries. How in the world is that even remotely possible? Oh, that's right. His left eyelid had a red mark behind his glasses. Now, the only reason I had his glasses passed around is just to show you that the hard part on the nose is there, like on most glasses, and if he was hit in the face, he'd have a mark. It'd cut him. If it was that hard that he literally thought he was going to die at some point because that's how violent Chad Olson was, the most easily bruisable person, because he testified he's easily bruisable. Jennifer Shaw testified he's easily bruisable. A phone is thrown at him. Now he changed his story. First he said he was hit with a fist. Maybe the hand had a phone in it. Now the phone was thrown at him. This phone never, ever touched him in that manner. Ever. Ever. And if you remember, there's so much information that comes about sometimes. You know, you almost have to be like an encyclopedia of knowledge. If you remember back when he was testifying, he said something really interesting if you caught it. Okay? He said, because you couldn't see Chad Olson in the picture frame, that he was too far away from him when he threw that phone. Very interesting that he said that. But here's something else. Remember, he changed his story. Because in the post-Miranda statement, when Chad Olson jumped up, the popcorn fell. So based on his statement, and you have to listen to the whole thing because he talks about it and then they go over it. He says the popcorn went by the wayside almost immediately. Which means when you see that video and Chad Olson standing up, we shouldn't see the popcorn, or we should see it fall. But what we really see is popcorn being tossed and then a shot takes place. That's how we know with 100% certainty the defendant wasn't being truthful. But what's he say? He says that when Chad Olson stands up and the popcorn falls by the wayside, it's at that time this attack happens that's not seen on video or by anybody in the theater, including his wife. And he says at that time is when he was hit by the phone. But he doesn't really know, because when he looked down, he saw the phone, so he just put two and two together. But on the stand, he talks about this phone attack happening 8 seconds before. How in the world is that? He changed his story. Now we have two unreasonable stories I submit to you. Self-serving stories don't equal self-defense. If he was hit by a phone, or even if he was hit by a fist from a 6'2" person who's raging mad, how in the world does he not have an injury other than a left eyelid behind glasses? You know why? Because it didn't happen. He was explosive and he was mad about the popcorn. That's what this case is. He started it and he ended it. Those are the shiny objects. So let's talk about what this case is. What's the credible evidence? You take those shiny objects, you put them away. What's the credible evidence in this case? We know that the Olsons came to the theater on a Monday. They dropped their daughter off at daycare. They sit in the theater, second to back, last row. We know at some point one of them wanted another piece of candy or something. Chad Olson goes out to the concession stand and comes back. I believe if you look at the video, it looks like they're there first. It doesn't matter. Then the defendant and his wife sit behind them. He has his phone. He's not talking. He's not conducting business. The light's on. Previews come on. Now, according to Jane Roy, who doesn't know anybody and would have no reason to come in here, say anything other than what she observed, she said almost immediately after the cell phone message came on, boom, here comes the defendant. Now, it's the previews. I'm not saying he should have his cell phone on. Certainly doesn't justify what happened to him. And do you really believe that this cell phone light was so incredibly bright that it was ruining his movie experience for the previews? Anyway, that's not even a big issue whatsoever. So what happens? The defendant leans in. Now, I submit to you, based on all the evidence that you've heard, he does not lean in and say, "Sir, I'd really appreciate it if you would just turn your cell phone off." No. Not the guy that is into the adrenaline and the danger and likes to be in control. Nicole Olson and Jane Roy, who don't know each other, testified about the defendant's demeanor. He leaned in and he was telling Chad to turn his phone off. He did it twice. Now, with a person who perceives himself as vulnerable, I don't want, I got a lot of things going on. I don't want to really get into any roughshod, and I can always de-escalate it with my background training experience. Does that guy get up right away to go to tell the manager? No, he's got to lean in a second time and tell him he's going to the manager. Why do you have to tell someone you're going to the manager? Get up and go to the manager. But he wants Chad Olson to know. So he leans in and tells him.
The passion is flowing to this morning in the close. Let's take a break here, pick it up right where we left off. Stay with us.
In honor of Black History.
The movie Popcorn Murder trial is nearing its end as attorneys are delivering closing arguments today. Defendant Curtis Reeves has gone to great lengths to tell jurors that he claims he acted in self-defense when he shot and killed Chad Olson in a movie theater back in 2014. He told jurors his account from the witness stand, testifying on his own behalf as the victim's wife sat silent in the gallery. Reeves said he viewed Olson as a volatile man when he asked him to put his phone away. And he claimed that he tried to de-escalate the situation before he fired his weapon. This morning, the state has been arguing that Reeves fabricated an unbelievable story about his encounter with the victim. Here's more from prosecutor Scott Rosenwasser and his closing argument.
So he leans in and tells him. So he gets up, he goes. Now, what does Jane Roy say? He's mumbling to himself. He appears agitated, he appears angry. And this is when it starts to begin, when we're talking about ill will, hatred, spite, or evil intent. And it culminates, whatever how many minutes later it is. I don't know if it's 3, 4, 5, it doesn't matter. But it culminates after the popcorn when he explodes, throw popcorn in my face. This is when it starts. Because Chad Olson, should he have turned his phone off? Sure. But he's like, look, man, just leave me alone. Mind your own business. Do what you got to do. So he gets up and he goes to the manager. Jane Roy testified that he appeared agitated. Now, we have a video that's in evidence. You watch it. I'm not saying that he was at the desk yelling and screaming. Witnesses came in and said, okay, he was there and he was talking. Now, these witnesses testified, I think her name was Simpson and maybe Mr. Peck, that Well, he came, he was telling us about what happened, he was polite. But when you watch his mannerisms, he could very well be polite, but he was certainly agitated. And remember something that Vivian Reeves testified to. These are just little nuggets. If you don't recall it this way, absolutely do not just take it from me. You have to rely on your own memory. But even she said she was kind of ticked off. Now, he goes and he tells the manager. Now, he doesn't tell the manager. What could he have done? He could have stayed and waited for the manager to go. But when I asked him that question on cross, well, what did he say? Oh, the manager told me to go back. He still could have stayed there. He could have waited for the manager. Just because the manager tells him to go back, all of a sudden, oh yeah, I'll just... If he was really concerned, could have waited for the manager. So he goes back into the theater. Now, this is where I submit he was being truthful. He goes back into the theater, and what happens? Chad Olson, either he put it away or he turned it off. It doesn't matter. It truly doesn't matter. The point being this. The issue has been resolved. Everyone can enjoy their movie experience. So what does the defendant do? The person that's trained in de-escalation, does he sit back down in his seat and let it go? What's he do? He initiates again. He pokes him. I see you put your phone away. I wouldn't have had to go telling you. Why in the world does he have to say that? Because he's the alpha male. He wants to let him know. Because he's used to being in control. It's like getting in the last word with a kid. It's spiteful. He could have just sat right down. So Chad Olson, what's he do? Well, as the defendant states, because there are some gems in there, okay? The defendant states that he then turns around in his seat, and it's a big difference, in versus jumping up. Now, the reason that I gave those photos to you, the defense photos, was for you to see with your own eyes that he was, in fact, turning around in his seat to have this conversation. And who's that consistent with? Derek Friedoff. Remember what Derek Friedoff's testimony was? Going back before the manager, Derek Friedoff testified he heard bickering. Bickering's an interesting word to choose. When your kids bicker, you know your kids are kind of like back and forth. They're not having a friendly conversation. There's bickering. So when the defendant wants you to believe, sir, I'd really like for you to turn your phone off. That's not what Derek Friedoff testified to. And what did Derek Friedoff say? When he went to the manager, everything settled down. Homeostasis, everything's fine. And when does the bickering start up again? When who is reintroduced into the equation? The great instigator. And now it's back up again. Because he started it and he ended it. So Chad Olson turns around in his seat, and I gave you those pictures to look at because had he been standing, he would have looked the way that he looked at the time that he was shot, at the time that the popcorn came into play. He's standing there, he turned around in his seat before. Now remember, Derek Friedoff told you, and even the defendant said this, at no time was Chad Olson turning around prior to the popcorn and initiating a conversation with the defendant. He was always looking forward. He was the one out of the two that was trying to de-escalate it. Now, he could have remained quiet, but I submit to you the defendant would have just kept going and going and going. But he's looking forward. Leave me alone, sir. Leave me alone. If anybody, Chad Olson is trying to de-escalate the situation from the person that's instigating it. So what happens? The credible testimony is this, that at some point in time, he does get up. And at some point in time, it's clear as day what he does. He leans over and he grabs the popcorn and he flicks it on him. Is it reasonable to believe that this defendant, with all his background, training experience, and his karate experience that we're going to absolutely address in a little bit, felt that when that popcorn bag was grabbed from him, he was going to die? Because that's what some of the instruction for the law of self-defense is. Did he reasonably believe he was going to die right then and there? There is no way in the world. Or did he reasonably believe that he was about to suffer great bodily harm? Now, there may be an argument made, well, you know, he didn't know that he was going for the popcorn. He just saw a hand coming at him. We're going to address that whole thing right now. First of all, we know it's about the popcorn because that's the statement. Don't lose fact of that. Okay? If you hear, oh, a hand's coming at him, he reasonably believes because a hand was coming at him. No, he killed them because of the popcorn, because he said that right after the shooting. Throw popcorn in my face. He knew what happened. It's not just a hand's coming towards him. He knew what it was. And when you watch the video, you see the popcorn and you see from the hip the shot. That's this case. Let's say you want to make the argument that he didn't know about the popcorn. You'd have to disbelieve Derek Friedoff, Mark Turner, Charles Cummings. And let's say you wanted to make the argument he saw a hand coming at him. Did he reasonably believe that that hand was going to kill him? Absolutely not. Did he reasonably believe that that hand was going to punch him so hard that his orbital bone was going to fracture and go into his brain? Come on, no, that's unreasonable. And you can't shoot somebody for punching you. You can't. Oh, he's vulnerable. That's what no, he's not. He's an instigator. He's not this vulnerable person. Okay, so he's sore. You can't kill anybody for that. So Chad Olson stands up. Now, there's a lot of dynamics going on. He grabs the popcorn, he tosses it, he's shot and killed. In that time frame, Nicole Olson's standing up, and she's just like, honey, come on. Now, the defendant wants you to believe there's this royal battle between Chad and Nicole. How is it no one sees this royal battle? How is it? How does Vivian Reeves, who's right there, not see this battle? If you want to say, well, Nicole Olson's saying there's no battle because she's got an interest in the case, how does Vivian Reeves not see a battle right in front of her eyes? How does no one hear or see this life and death struggle? Because remember, I asked him on the stand, was this a life and death struggle? Oh, yeah, this was a life and death struggle. In my entire career, I've never seen anything like this. Come on. So he shoots and he kills Chad Olson and basically shoots off Nicole Olson's finger. And we know why. So what's the law in this case? What was the defendant charged with?
All right, let's get a quick break in here. We'll pick it up right where we left off. Boy, what a closing argument. Back with more after this.
This is an important message for everyone.
Welcome back to Court TV Live. The fate of defendant Curtis Reeves will soon be in the hands of a jury. After attorneys finish their closing arguments, that jury will be tasked to decide if the defendant acted in self-defense like he claims when he shot and killed Chad Olson in a movie theater. He's accused of second-degree murder and aggravated assault for the 2014 incident. Did the defendant, hours on the witness stand yesterday, telling the jury about his long career in law enforcement and then about the day that he shot and killed Olson in the theater. We'll soon find out what effect, if any, his testimony had on those 6 jurors. Now, back we go to Dade County and the courtroom right where we left off. Prosecutor Scott Rosenwasser is on a roll delivering his close.
There's a lot of laws that apply to this case. At first glance, it might seem confusing. It's going to be like a law school class. And we're going to talk about it. So the defendant has been charged with second-degree murder. When you hear murder in the second degree, it's the same exact crime. For whatever reason, in the jury instructions, they flip them around. It's the same crime. He's also been charged with the crime of aggravated battery. That's for shooting Nicole Olson. Now, at the beginning of the instruction for second-degree murder, you're going to hear about this. This is called Introduction to Homicide. This is either going to work or it's not going to work. We're going to say that it's not going to work right here.
It'll work.
That's all right, I'll give you a second. All right, so let's use this one just for now, okay? Don't need that other one. All right, so introduction to homicide. Make sure everybody can see this. If I put this right here, can everybody see it?
No.
Can everybody see this now? Okay. All right. Introduction to homicide. So this is the instruction that you're going to hear. In this case, Curtis Reeves is accused of murder in the second degree. Murder in the second degree includes the lesser crime of manslaughter, which we're going to talk about, which is unlawful. A killing that is excusable or is committed by the justifiable use of deadly force is lawful. If you find Chad Olson was killed by Curtis Reeves, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. So let's talk about justifiable homicide. This is the instruction. The killing of a human being is justifiable homicide and lawful if necessarily done. So let's talk about that. Every word in jury instructions is important. Okay? Necessarily is very important in this instruction, meaning, was it absolutely necessary and it makes sense? Because if you're taking a human life, you got to be 100% sure. There's no gray area when you're taking another person's life. It's justifiable homicide and lawful if necessarily done while resisting an attempt to murder. Okay, we'll just throw that one out. We know there's no attempt to murder the defendant. While resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house. All right, so this last sentence here is about in the home, doesn't apply, we're in a movie theater. Okay? So was it necessary while resisting an attempt to commit a felony? All right, so let's talk about that. And that's why I'm talking to you about necessary. Okay? We're going to talk about this in just a second. I just want you to keep that in mind. Okay? Is it necessary? That's justifiable homicide. Then you learn about excusable homicide. Now, here's excusable homicide. Can everybody see that? The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. Now, the reason that when I started my cross-examination with the defendant, I asked is, was this an accidental shooting or did you intentionally shoot him? You know, me and well, why would we ask that question? This is exactly why, just to cover. Okay? This is not an accidental shooting. This is an intentional shooting. It's just that he's saying he intentionally shot him and it was lawful self-defense. Everyone understand what I'm saying? This is not an accidental shooting. It's an intentional shooting. He's just saying he had a defense to it, which I submit to you obviously wasn't very credible. All right, everyone understand that? That's what this means. When the killing is committed by accident and misfortune in doing a lawful act. So let's say someone's cleaning their gun and the safety's off and the table leg breaks and the gun falls and someone dies because the gun went off. That is an accident and misfortune. The defendant intentionally shot Chad Olson, so none of these apply. By law, though, you might say, well, why are we hearing about these then? Because the law requires that you hear this. That's why you're hearing it. The law requires it. When the killing occurs by accident, number two. Number three, committed by accident, and it talks about a dangerous weapon not being used, okay? Accident, accident, accident. This whole instruction doesn't apply, okay? Number three talks about a dangerous weapon, okay? And then there's a definition. A firearm is a dangerous weapon. So the whole excusable homicide doesn't apply to this case. Again, the law requires you hear it. That's why I'm telling you about it. So what's the crime of murder in the second degree? So here, remember we were talking about at the beginning of closing arguments that crimes are built of elements. And when you go to school, the way people explain it are their building blocks. And we have to prove each of these elements to you for the crime. The way it works is this. There's a highest crime that's charged. The highest crime that we've charged in this case is called murder in the second degree or second degree murder. Again, it's interchangeable. If and only if you feel we have not proven that crime beyond a reasonable doubt, do you go to the next one that we're going to talk about, which is right here, manslaughter. Okay? We're going to talk about that one in a second. This is the main crime that's charged. When you deliberate, you start with this one. You take all the credible evidence, and you take those facts, and you go down the line. Okay, number one, Chad Olson is dead. Obviously, we have that. So we know that element's satisfied. Okay? So that's how you analyze a case as a juror. So let's talk about what second-degree murder is. Element number one, do we prove that? Yes. Element number two and element number three go together, and that's basically what the defense is in this case. Element number two, the death was caused by the criminal act of Curtis Reeves. Number three, there was an unlawful killing of Chad Olson by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Then there's definitions. An act is imminently dangerous to another and demonstrating a depraved mind if it's an act or series of acts, and then there's more things. So you take all the credible facts and you apply them to the elements. Would a person of ordinary judgment, would that person know it's reasonably certain the act was an act reasonably certain to kill or do serious bodily injury? Okay, if you shoot someone basically in the chest, obviously a person of ordinary judgment would know that act would kill somebody or seriously injure them. Number two, we're going to save for a minute. Number three, the act, which is the shooting, right? That's the act. Okay? So is the shooting, would a person with ordinary judgment know shooting person in the chest could result in death? Yes, that's number one. Number three, is shooting someone in the chest a nature, is that an act that itself indicates indifference to human life? Absolutely. If you shoot someone with a firearm in the chest, obviously it's an act that's indifference to life. The one that we need to discuss is that this act, the act of shooting, was the defendant shooting Chad Olson, an act done from ill will, hatred, spite, or evil intent. Now that's the issue for second-degree murder. So in order to determine whether or not when he shot him, he was acting from a place of ill will, hatred, spite, or evil intent, that's when you go back to the totality of circumstances that we had just been discussing. In a very summarized fashion, it's the cell phone light bothering him. That's the beginning. The interaction, the instigation to have that cell phone turned off. When it's not, to get up to go tell the manager, to come back and reinitiate the contact. That's all evidence of ill will, hatred, spite, or evil intent. And when he takes that firearm out and he puts it to his side, when he slides it up from that pocket, because I submit to you that's exactly what happened. And when that popcorn went on him, he lunges. Again, you have to watch that video because it's very powerful to see. It's like he's saying, and that action in and of itself, when you look at everything, was done from ill will, hatred, spite, or evil intent. Coupled with the statement.
The great instigator is what Scott Rassenwasser calls the defendant. He says he started it and he ended it. We'll take a break, pick up right where we left off as he concludes his opening statement. Then, what's our closing argument? Then the defense with an opportunity to address this jury one final time. Stay with us.
Buckle your seatbelts.
Welcome back to Court TV Live. Let's shoot back into the courtroom. We're going to pick it up right where we left off with the closing arguments.
However it was worded from the witnesses, the impact of it is throw popcorn at me, throw popcorn in my face. In other words, who are you to throw popcorn at me? And he lunges forward and he kills Chad Olson. Do all those acts show you that when he shot Chad Olson, that he did it with ill will, hatred, spite, or evil intent? And I submit to you, it does. He started it, he ended it, and it was a man that was killed over a popcorn toss. Now, if you do not feel that we have proven the case beyond a reasonable doubt for murder in the second degree, then and only then do you get to manslaughter. Now, one other thing that I want to bring up about second-degree murder. On the verdict form, you're going to see what are called interrogatories. So on the verdict form, there's questions after the crime. So let's say that you believe, and I submit to you, we've proven that case beyond a reasonable doubt. You would check off that the defendant is guilty of murder in the second degree. Then there's 3 questions, and you would only check one of them. And it will say, did the defendant, I'm paraphrasing a little bit, did the defendant possess a firearm? The next one would say something to the effect of, did the defendant possess and discharge a firearm? And then the third one would say, did the defendant possess, discharge, and cause great bodily harm or death? Now, obviously, that's what this case is about, and you would check the third question. By law, you have to have all these things done. That's why I'm telling you about that. All right, so if you feel as though, and I submit we have proven that case beyond a reasonable doubt, but if you feel as though we haven't, the next crime is called a lesser crime. It's called manslaughter. This is the law of manslaughter. Element number 1, Chad Olson is dead. Obviously, that's been proven. Then you could do 2A or 2B. Curtis Reeves intentionally committed an act. Did he intentionally shoot Chad Olson? Yes. That caused the death of Chad Olson? Yes. You really don't have to go to 2B. If you go to 2B, you have to read, there's a long instruction. I'm not going to read it to you. You're going to have it in your jury packet, or Judge Barkel's going to read it to you. But really, 1 and 2A is fine. So what's the main difference between murder in the second degree and manslaughter? Whether or not someone acted with ill will, hatred, spite, or evil intent. That's the only difference. So if you find that the defendant shot and killed Chad Olson, but it just wasn't legally justified, it was not a lawful shoot, it was a bad shoot, that would be the crime of manslaughter. Murder in the second degree is if based on the totality of circumstances, ill will, hatred, spite, or evil intent. So manslaughter is a lesser included crime. If you do not feel as though we've proven second-degree murder beyond a reasonable doubt, there can absolutely be no doubt. I submit there isn't for murder in the second degree, but it's certainly manslaughter. This was not a justified shooting. Absolutely 100% not a justified shooting. That would be manslaughter. Under manslaughter, there would be 1 interrogatory, and it would just say something to the effect of, was a firearm used, or something like that. The other crime that the defendant's been charged with is a crime called aggravated battery. Okay, and again, you're going to hear all these instructions. Aggravated battery is basically this, that the defendant intentionally touched or struck Nicole Olson against her will. Okay, and it sounds silly, but you just have to bear with me for the explanation. He shot her, so obviously he intentionally touched or struck her against her will. You don't have to use your own body if a shooting counts, because he was the mechanism behind touching or striking her against her will. In committing the battery, did he intentionally and knowingly cause great bodily harm to her, permanent disfigurement, or permanent disability? Well, her finger was basically shot off. You saw the photographs. Or, number 1, did he intentionally touch or strike her against her will? Yes. Number 2, in committing the battery, did he use a deadly weapon? That's probably maybe the easier way. Yes, he used a firearm. Okay, a weapon's a deadly weapon. If it's used in a way likely to cause death or great bodily harm. That's the definition you'll get. Obviously a firearm. Okay, so that's aggravated battery for shooting Nicole when she had her hand up. Now, you think, well, how could that be? Well, there's a law called transferred intent. And here's the law for transferred intent. Basically, if a person intends to shoot a person, so if the defendant intends to shoot Chad Olson, and in the process shoots a different person, Nicole Olson, the law transfers the intent to shoot the intended person, Chad Olson, to any person who was actually shot. So it sounds kind of circular, but because he intended to shoot Chad, and Nicole had her hand up, and he shot Nicole, the intent is transferred to her. Now, the caveat to that is if you find that he was acting in self-defense, then it doesn't apply. Okay? That would be the caveat to that. So what's this case really about? Okay? The defendant is claiming that he lawfully acted in self-defense, that there was a justifiable use of deadly force. This instruction is a little bit complicated. I'm going to go through it just to explain what it states. An issue in this case is whether Curtis Reeves acted in self-defense. It's a defense to the crimes of both second-degree murder and manslaughter. If the death of Chad Olson resulted from the justifiable use of deadly force, and deadly force, of course, means what happened here, the defendant shooting him with a firearm in the chest. Now, that reminds me of something that I need to address. Real quickly, at the very bottom on my board, and you're going to get this instruction, we do not have to prove for second-degree murder that the defendant intended to kill him, just that he intended to shoot him. And the fact that he died is fine, if that makes sense, okay? Not that, him dying, of course, is nothing fine. But we don't have to prove that when he shot him, he meant to kill him. We just have to prove that he shot him and he died, okay? That's what this means. In order to convict a second-degree murder, it's not necessary for the state to prove the defendant had intent to cause death. Just that he shot him and he killed him. Okay, just a little teeny distinction. All right, back to justifiable use of deadly force. Again, every word in here is incredibly important. The use of deadly force is justified if Curtis Reeves reasonably believed. So remember, in the first instruction, was it necessary to kill Chad Olson? Absolutely not. Here, did Curtis Reeves reasonably believe that the force was necessary? So you kind of paraphrase that. The use of deadly force is justifiable if Curtis Reeves reasonably believed that shooting and killing Chad Olson was necessary to prevent his imminent death or great bodily harm to himself, while resisting an attempt to commit the felony offense of battery on a person 65 years of age or older. All right, so that seems like that's like a loaded paragraph. Let's break it down, okay? There's a crime called battery, okay? And we talked about it. I was cross-examining the defendant about it. Battery is when you intentionally touch or strike someone against their will. Bob is walking down the street. He punches Joe. That's a battery. He slaps Joe, pushes him, trips him.
We need to step aside, take a short break. A quick programming note, a new Court TV special on the cases that are Black history in the making airs tonight. Court TV anchor Michael Ayala will have an all-star panel with him, including attorney Ben Crump, Mark O'Mara, of course, the man who defended George Zimmerman, who was later acquitted for killing Trayvon Martin. Also on the panel, trial attorney and frequent guest here on Court TV, C.K. Hoffler. Michael, we'll take a look back on the Black icons of the past and talk to our panel about the cases changing the course of legal history as we live it. You can watch it. It's tonight, 7 p.m., 6 o'clock Central, right here on Court TV. We're going to step aside, take a break as we approach the top of the hour. More closing arguments in the movie Popcorn Murder Trial. We'll pick it up right where we left off after this.
I absolutely hate
Top of the hour, welcome back to Court TV Live. We're watching two big trials play out this morning here at Court TV. First in Louisville, Kentucky, former police officer Brett Hankinson faces 3 counts of wanted endangerment for firing his gun in the raid that ended in the death of Breonna Taylor. Prosecutors claim that Hankinson neglected protocol when he fired his weapon, endangering the lives of Taylor's neighbors. You can watch testimony today on our website, streaming at courttv.com, along with our YouTube channel. And in Florida, closing arguments underway this morning in the movie Popcorn Murder Trial. Defendant Curtis Reeves spent all of yesterday on the stand testifying to what he believed happened just before he shot moviegoer Chad Olson. He told jurors that he thought Olson threw a cell phone at him, but when he was shown the surveillance video again on cross-examination, he didn't have a lot of answers for that. Let's take you back into that Dade City courtroom. Prosecutor Scott Rosenwasser is delivering his close. We'll pick it up right where we left off.
Throws popcorn on him, throws soda on him. That's a battery. That's a misdemeanor crime. Now, if someone is over the age of 65, it becomes a felony only because of the age. That's the only difference, which is why you're hearing about this crime. Battery over 65. So Bob and Joe are walking down the street. Joe is now 66, 69, let's say 71. And Bob pushes Joe or punches Joe. It's a felony, but because he was over 65. That's it. So, looking back at this instruction, the use of deadly force is justifiable if the defendant reasonably believed that shooting and killing Chad Olson was necessary to prevent imminent, meaning right then. Would it be reasonable for the defendant to think, at that time, sitting in the theater, with the lighting condition as they were, where people can see, people can hear, is it reasonable to believe, would a reasonably cautious and prudent person believe they were about to die? Absolutely not. So shooting and killing Chad Olson wasn't necessary to prevent imminent death or great bodily harm to himself. Okay, great bodily harm. There's a definition for great bodily harm. It doesn't include bruising. It doesn't even include moderate harm. It is what it is, great bodily harm. Would a reasonably cautious and prudent person in the defendant's position, with all this training about de-escalation tactics, would a reasonably cautious and prudent person believe that as he sat there and the hand came across and grabbed that popcorn, that he was about to suffer great bodily harm? No. This is not a justified killing. Absolutely not. Now remember, don't lose fact of what the sentence was that he said, because it's not just a hand coming towards him. He knew popcorn was thrown at him. He knew that bag was grabbed. And when you watch the video, you can see it. The bag, the popcorn, and he shoots, and he lunges forward. And he says, don't throw popcorn at him. He knows it. It's not just a hand coming in that's so important. But again, let's just say for some reason you want to discount that. A hand coming in does not lead a reasonable person to believe they are about to just be beaten to a pulp. It's simply not true. And he started it. And this felony offensive battery is only because of his age. That's it. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death. We already talked about that. Or great bodily harm. We talked about that. Or the imminent commission of, there should be a Y here, but imminent commission of aggravated battery against himself or another. So let's talk about that. We got to break that one down. Did he have to kill Chad because he felt he was about to die? The answer we've already covered is no. Did he kill Chad because he thought he was about to be beaten to a bloody pulp by a hand just coming in? Again, don't focus on that. He says the popcorn, he knows about the popcorn. So none of this applies. So let's talk about where the imminent commission, meaning about to happen. That's what it means. Imminent commission of this crime. Was he about to have an aggravated battery committed against him? Okay? So what's the evidence in this case? And you really got to analyze this. The evidence is this. He reaches in and he grabs the popcorn. He brings it back, he throws it. His hand is on his way back. Nicole Olson has her hand coming up. He's killed. Is there anything that is about to happen? No, because he had already just completed the act. In fact, he wasn't even so far back to start anything because he was shot for throwing the popcorn. Did he shoot someone because he was about to be attacked? No, the popcorn had already been thrown and that event was over. And you can see it in the video as well. He throws it and as his hand's coming back, that's when he shot and killed. There's no imminent commission of anything else. Now, let's say that the fact pattern was that he throws the popcorn and he stands there for a couple minutes and now he starts to jump over the seat and attack him. That would be a fact pattern that would apply here for this instruction. But in this case, the video shows you that he had thrown the popcorn, his hand was coming back, and that's when he was killed. And it's all about the popcorn. That's why the defendant is not justified in killing Chad Olson. That's what these instructions say. Now let's look at this paragraph because it's extremely important as well. In deciding whether Curtis Reeves was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used, meaning the shooting. At the time of the shooting, what were the circumstances? Okay? I know I'm repeating it a lot, but it's so important. At the time that the defendant shot and killed Chad, he had already thrown popcorn on him, his hand was coming back, and he shot him because of the popcorn. That's the circumstances. So at the time he shot him, what was happening? His hand was coming away. And he knew it was about the popcorn. Despite what he says in any of his statements, both of them, that actually contradict each other, that's not believable. Those are the facts. Now, the danger facing Curtis Reeves need not have been actual. Now, I blew this particular part of the instruction up because it's really important as well. In deciding whether Curtis Reeves was justified in the use of deadly force, you must judge him by the circumstances. That's what we just discussed. The danger facing Curtis Reeves need not have been actual. However, this is what applies. It need not have been actual. However, to justify the use of deadly force. So the danger facing Curtis Reeves need not have been actual, but in order for him to shoot and kill Chad Olson, the appearance of danger must have been so real that a reasonably cautious and prudent person under those circumstances would feel that the only way to avoid what happened was to kill Chad Olson. Okay? Now, what would be an example of this? Because it's not this fact pattern. This fact pattern doesn't even come close to this. Okay? The appearance of danger must have been so real. Okay? The defendant is sitting in his chair. He's just instigated this person. He reaches over and grabs the popcorn, and now it's coming back. That's the circumstances. That's it. Okay? There's no imminent commission of anything. He had just completed throwing the popcorn. Again, we know it's about the popcorn from the statement. But what would be an example of this? Okay? Because it's very important not to be confused by what this means. Here's an example of how the appearance of danger must be so real that a reasonably cautious and prudent person would think they have to kill another human being. Two people get in a road rage incident. They pull over to the side of the road. Driver 1 gets out. Driver 2 gets out. Driver 1 starts making some threats to driver 2. I'm going to kill you, you mother, yeah, I'm going to kill you. Okay? Now, in this case, there's no threats like that. Now, the defendant wants you to believe there's threats. But remember, not a single person hears any of these threats because it didn't happen. Driver 1 gets out, driver 2 gets out. Driver 1 is threatening to kill driver 2. Driver 1 suddenly turns around, runs back to his car, reaches in, grabs his wallet, turns around with this black object. Driver 2 is like, oh my God, this guy just said he's going to kill me. He's turning around with a black object. I'm going to have to kill him. Bam! The appearance of danger was so real that a reasonably cautious and prudent person under those circumstances would realize that shot had to be taken. That would be a perfect textbook example of what this means. because he was just threatened. Someone was going to kill him. The guy turns around and runs back to his car. He grabs a black object. Now, could that wallet have killed driver number 2? Of course it couldn't. But the appearance of danger was so real. He threatened to kill him. He ran to his car. He grabbed the black object, and he suddenly turned around. Any reasonable person under those circumstances would say, yeah, I can see how that guy would think that a gun was just taken out. Obviously, that wallet couldn't kill him. But
Quick break. We'll be back right after this with more of the prosecution's closing argument. Stay with us.
Police officer shot and...
Back to the courtroom we go. We'll pick it up right where we left off as the state finishes up its first half of its closing argument.
I would have shot him too. Textbook example of what this phrase means. It does not mean that because Curtis Reeves, in his mind, believed this imaginary attack happened, that he's justified. Because a reasonably cautious and prudent person in his situation, sitting there, having popcorn just dumped on his lap, would not believe you have to take another human being's life at that moment. It even sounds crazy to mention it out loud, but that's the fact pattern in this case. This instruction does not justify killing Chad Olson. Even if he reasonably believed that he didn't. I submit to you, he made up a story in the cruiser to cover his tracks, not realizing so many people saw it, and not realizing the silent witness video captured the whole thing. He didn't reasonably believe for a second his life was in danger. And that's why he changed his story from his post-Miranda statement. Because think about what he did. Think about this. He went from 1 attack to 2. Because what does he get by changing his testimony to 2 attacks? This reasonable belief that something's happening. The day of the shooting, again, I submit to you this story is not even credible. But he says that he was attacked after the popcorn fell, completely dispelled by every witness and completely dispelled by the video. But during the trial, he changes his story to say, you know what happened? It's funny because I asked him, you remember, I said, what? How in the world do you get these 2 stories? He's like, I don't know. How do you not know when you kill another human being? So why does he change his story? Because he has to add an attack. Because he knows that post-Miranda statement is so bad for him. So he changes his testimony, and he indicates this. He states, no. The popcorn didn't go to the wayside, and I wasn't attacked with him virtually on top of me. Remember he's saying all that? Remember his first statement? So what happens is I'm sitting there, and he jumps up, and the popcorn falls by the wayside almost immediately. And now he's coming over on top of me. And I'm back in my chair. Well, that's when he was getting the gun, in reality. But let's go with his statement. I'm back in my chair, leaning back, and I got my left hand out. And I'm yelling, no, and whoa. And I'm touching his chest or his shoulders because, remember, his own words. He's virtually on top of me. He's in my lap. Well, on the stand, he's like, no, I meant leaning. What? The defense attorney is talking about minutia words to witnesses. He's changing from virtually on top of me and in my lap to leaning? Are you kidding me? How many reports do you think he's written in his life where it's important to be truthful and accurate? Come on. Because he's painting a picture that he had to kill him. Not knowing there's a video out there to disprove it. So he says he's got his left arm out and he's touching his chest or his shoulders. And, I gotta kill him. I can't believe I didn't shoot my hand because my left hand's out as I'm fighting him off in this life or death struggle. That's truly not happening. And we know that didn't happen for several reasons. One, there's no stippling on his left hand. Everyone that was shot, everyone that was in front, of his gun has stippling. Nicole and Chad. How is it that he doesn't have stippling on his left hand? Well, possibly it's the same reason why he doesn't have an injury from a phone that was thrown at him. He's not some magic person. It's because it didn't happen. But you don't even have to look at that common sense argument. You just have to watch the video. I played it slowly and rocked it back and forth like you can do it in the jury room to show you that what actually happened is as he's shooting out from the hip, when the popcorn hits him because he's mad, he takes that left hand, you can clearly see it in the video if you watch it, and based on his muscle memory, he slaps it against him so he doesn't shoot his hand. So when he's like, oh my God, I'm so surprised I didn't shoot my hand, watch that video. His left hand goes up, and based on his muscle memory, he immediately brings it to his chest. And that's exactly what happened here. He intentionally killed Chad Olson because he was mad. You see it plain as day on the video. In court, he changes the story, and what's he say? In court, he says, well, I came back from the manager and he was staring at me. Now, why was that important? Because he wants to be like, I'm the great de-escalator. You know, to calm him down, I wanted to tell him everything's all right. But he didn't tell that to Detective Proctor, because to Detective Proctor, he says, I reinitiated, because that's truly what happened. Then, on the stand, he gives this version. Well, I came back from the manager, and that's when I was attacked, a full 5, 6, 7, 8, whatever the number is, seconds before. So when I saw his hand coming towards me, that's why I realized I had to kill him. But we know for a fact that didn't happen. Number one, why would he change his story? Number two, what's this first attack that happened 8 seconds before? Well, first he says that he's hit with a fist. Then he says it's a fist with a phone in it. And finally on the stand, he threw the phone at me from some distance. Because I demonstrated on the video that he wasn't even in the camera when it happened. Let's just go to the next illogical thing. How in the world was it that he's able to be hit with a phone and not be injured? How in the world is he hit with a phone and his wife, who's sitting right next to him, doesn't see it happen? How in the world does not a single person in a theater see that happen? How in the world is it not captured on video? How in the world does he get hit with an object so hard that he continues to go forward and not react with his hands? That's because he's trained in karate. That's what his testimony was. Not even making that up. No human in the world gets hit with a phone that hard and doesn't yell, ow, oh my God, I can't believe this, and go for their head. It never happened. None of it happened. What happened was he killed Chad Olson for no reason other than the fact he was mad. And if you don't believe that's the reason, he unlawfully killed him, and it's manslaughter. I'm going to show you 2 pictures. I'm going to show you 2 pictures, and these pictures tell you the story. In my left hand, this is the defendant, Curtis Reeves. You may see that his left eyelid is red. From all accounts, people testified that he was touching his face afterwards. The detective indicated that he was rubbing his eye. This is Chad Olson's picture. Did this person reasonably believe this was necessary in this case and in this fact pattern? The defendant is guilty of either murder in the second degree or of manslaughter, and he's guilty of aggravated battery as well.
Thank you, Mr. Rosenwasser.